The webinar will begin in 2 minutes. The webinar will begin in 1 minute. Welcome everyone, and thanks for joining us for today's webinar, Answering the Most Asked Questions About Medicaid Planning. The webinar will last approximately 15 minutes, and at the end, you will be given an opportunity to receive supporting materials by email free of charge to you. You will also be told how you may email questions related to today's content to the presenter. Today's presenter is Linus Sugis. Linus worked for a Chicago-based insurance company in various roles, including Director of Advanced Sales and as Chief Marketing Officer. He ran and sold a successful estate planning practice in Franklin, Tennessee. Linus also writes the publication Think About It, founded by life industry guru Steve Lineberg. And Linus regularly speaks at industry events. His new book, Sellout, The Busy Entrepreneur's Guide to Transferring a Closely Held Business, written together with a CPA and a business broker, is now available on Amazon.com. Linus will draw on his legal, tax, and life insurance background and practical experience for today's webinar. And here he is.
Thanks, Jennifer, and welcome everyone. I'm glad to be talking to you today about the most asked questions regarding Medicaid planning. We're going to spend about 15 minutes talking about Medicaid, and unfortunately we're not going to be able to give you much of an overview, but we will try at least a few minutes to talk about the role of Medicaid. But we'll spend the bulk of our time together talking about the questions that we commonly get at advanced underwriting consultants from producers who want to know more about Medicaid planning. So, but before we get into it, let's go ahead and open our poll about what it is that we're going to be talking about next month. You'll have 3 choices. Help us to pick a topic. First is reconsidering qualified charitable distributions, QCDs. Second is ethical issues with incapacitated clients. The third topic is another crazy beneficiary designation case. And so let's go ahead and open the poll and let you vote on one of the 3. I'll give you about 30 seconds. Let's go ahead and pick a topic for next month. Go ahead and vote. Still waiting on a couple more votes. Go ahead and vote, please. Give you another few seconds. All right, let's go ahead and close the poll. And it looks like our topic next month is going to be another crazy beneficiary designation case, one of my favorite topics. So there we go. We'll talk about that next month, beneficiary designations. All right, but today we're going to talk about Medicaid planning. And for a lot of us who work with older clients, they have a lot of concerns. They want to make sure that their money doesn't run out before they die. They want to make sure that their family, kids and spouse get their stuff. They want to manage death taxes, although that's less important these days with the dramatic increase in the federal estate tax exemption. But they certainly want to deal with the unexpected cost of health care and perhaps long-term care. The costs of medical expenses are perhaps the biggest exposures that a lot of our clients face. And a lot of times our clients don't have enough money put aside to deal with the cost of long-term care or other medical expenses. And so many of them rely on Medicare and Medicaid to cover the costs of those expenses. Medicare is essentially health insurance available to most everyone who's over age 65. Medicaid is a special program that is available only to those who can prove that they're poor. It's a welfare program. And it's different from Medicare, which you pay for either directly or indirectly. Medicaid is a welfare program available to those who are poor. And the reason that it's important is that Medicaid is the only program that potentially pays for the costs associated with long-term care. Medicare doesn't really do that. It pays for long-term care expenses only on a very limited, very selective basis. Medicaid pays for long-term care expenses on a more comprehensive basis. And so that's why it's important for those of us who are in the financial services business. You've got to qualify financially in order to get Medicaid. And to make matters even more complicated, the qualifications are much different for a single person as opposed to a married couple. If someone's single and they're trying to qualify for Medicaid, the countable assets that they can have can't be more than $2,000. Most assets count, including the cash value of life insurance and the cash value of annuities and the cash value of qualified plans. What doesn't count? The assets that don't count include things like clothing, furniture, jewelry, one motor vehicle, car, and the value of the applicant's primary residence up to a certain limit, just under 600 grand these days. That doesn't count against somebody who is applying to qualify for Medicaid. But if they've got more than $2 grand worth of stuff that counts, they won't qualify. The Medicaid folks allow people with income to qualify for benefits. And in general, they're allowed to have $2,300 a month or so of income and still qualify for Medicaid. That's the good news. The bad news is that if someone's single and they're getting that much income, they got to turn over all but $30 a month to Medicaid in order to enjoy Medicaid long-term care services. And so, you can see it's really a welfare program. These are real restrictions, real financial restrictions on somebody's ability to qualify. Well, what about a married couple? How does that work? Well, it's more complicated. I'm not going to get into it in a lot of depth, but Medicaid is interested in the healthy spouse being able to support herself or himself while the unhealthy spouse enjoys the benefits of long-term care services. Any assets that the couple has are generally considered to be available to help pay for Medicaid. the healthy spouse can generally keep around 25 grand, maybe a little bit more in certain states. The most that the healthy spouse can keep is 126 grand, and the assets are that are owned by the couple, whether the healthy spouse or the institutionalized spouse. They're all considered to be available to help pay for Medicaid coverage, and so that's why there's a limit on how much the healthy spouse can keep. In addition, the income that the community spouse, the healthy spouse, gets is generally not counted toward the sick spouse's Medicaid eligibility. And so there are some Medicaid planning strategies that involve creating an income stream for the healthy spouse that might help the sick spouse qualify for benefits earlier. Those strategies will vary from state to state. They're not available with every kind of annuity. So in any event, the waters end up getting pretty deep pretty quickly. People often ask us about gifts. Can people make gifts to family members in order to qualify for Medicaid more quickly? The answer is that there's a 5-year look back on most gifts to family members. For 5 years after the gift is made, Medicaid essentially pretends that the person who made the gift still owns the asset, and so they're going to be disqualified either in full or in part from Medicaid benefits. There's also a rule where if somebody qualifies for benefits and goes on Medicaid and collects benefits associated with long-term care, Medicaid has the ability to recover some of the costs or all of the costs associated with long-term care at that person's death. The most common way might be against the primary residence. Medicaid may be able to force the family to sell the primary residence after the sick person's death to recover the costs of long-term care. Those rules vary from state to state. It's highly complicated. And one of the takeaways that we'd want all the attendees today to have is that in order to provide effective counsel to your clients, they've got to have an elder care attorney on their team to help them think through these issues. And the reason is that a lot of the decisions about Medicaid planning that are made end up being irrevocable and just need to be thought through really well. Elder law attorneys in various places have various strategies that they use to help clients qualify for Medicaid early, including making gifts early, putting money that would otherwise be countable into exempt assets such as equity in the home, and to turn assets into income streams. None of these things should be done lightly. They all need to be thought about pretty carefully because, as I alluded to earlier, the decisions are in general irrevocable, can't be undone, and sometimes people will make choices to plan for the possibility of a long-term care stay, and then the person will die before they actually enjoy any of those benefits. And the strategies that have been employed pre-death are irrevocable, and they have consequences and may not be what somebody intended. So they really need to be thought through pretty carefully. Now let's jump into the questions and answers that we get asked a lot. First question is this: understand that in my client's state, IRAs are protected against the claims of creditors. Are those IRAs also exempt from Medicaid spend down? In other words, is an IRA accountable asset for Medicaid purposes? And the answer is yes. An IRA is a countable asset. Asset protection rules, creditor protection rules are much different from Medicaid qualification rules. Why are they different? Well, asset protection means that if somebody sues me, they can't collect against this particular asset. That's a general rule and a general protection that might apply in a particular state. Medicaid, on the other hand, is a government program for which you must apply and be approved. And you've got to put down all your assets on the application form, including your IRAs. And the federal government can certainly count an IRA as an asset that would preclude somebody from being able to collect benefits. And that's the reason why there's a difference. Next question. Does my client have to disclose information about, insert asset here, when applying for benefits? And the answer, of course, is yes. If somebody lies on the Medicaid application, they're lying to a government official. Failure to disclose everything about everything is a felony, and it subjects the application process to criminal and civil penalties. And if somebody lies on the application and gets benefits, of course, those benefits, if the federal government or the state government administering the program finds out about it, all those benefits, of course, will have to be paid back, and the client's at risk of being prosecuted. Next question, can my client give away $15,000 a year without being worried about the look-back period? $15,000 a year is the federal gift tax exclusion amount. You can make a gift of 15 grand a year to anybody you want without having to file a gift tax return, but such a gift is subject to Medicaid look-back. The tax rules and the Medicaid look-back rules don't interact. They're independent of each other. And so there is a look-back period on annual exclusion gifts. Can a single premium immediate annuity help a client qualify for Medicaid? And the answer is maybe. In most states, putting an asset that counts into a SPIA is not considered to be a transfer that would be subject to the look-back period. And it will transform an asset that counts into an income stream. And an income stream doesn't count as an asset, it counts as income. There are some specific requirements that are enumerated here on the slide to put together a Medicaid compliant immediate annuity. That if that's done, it may be effective for Medicaid purposes and may help somebody to qualify earlier. The downside is that for a single person, if that strategy is employed, as we mentioned earlier, all but $30 a month of the amount needs to be turned over to the Medicaid authority. If this is a husband and wife situation, sometimes the healthy spouse can keep the income stream, and that actually preserves the overall value of the assets. And so it can be an effective strategy. And that's why the answer to the overall question is maybe. Next question often gets asked, will buying a deferred annuity with an income rider help my client qualify? The answer is no. A deferred annuity is a countable asset, even if it's got some kind of income rider feature. One of the requirements that keeps a SPIA from being considered a countable asset is it can't be turned back into cash. A deferred annuity can be turned into cash, and that's why it counts. My client's buying a permanent life policy with chronic illness acceleration feature, acceleration of the death benefit. How will the policy be treated for financial qualification of Medicaid? Under current rules, the cash value of permanent life insurance is a countable asset. If the life policy has no cash value, Medicaid generally does not currently count it. And so if it stays in force, if there's an acceleration feature, that acceleration feature is available to help pay for chronic illness, but it won't count against somebody for Medicaid qualification purposes. So in theory, somebody might be able to get both. If the acceleration is exercised, that money becomes money and it goes into an account, and then it may qualify because it's an account. And so, those things need to be thought about pretty carefully when you've got somebody who's trying to qualify for Medicaid or other needs-based government benefits. If somebody's collecting Medicaid, long-term care benefits, receives an inheritance, does it screw it up? And the answer is probably yes. Any money, any inheritance ends up being an asset. When there's a change in your asset situation, you're supposed to notify Medicaid about that change. and the existence of an inheritance as a countable asset may kick somebody out of the program. And so if somebody in the family is collecting Medicaid or wants to qualify for Medicaid, asking them about any potential inheritance that would screw that up is the right thing to do. It may be that special needs trust planning for that person's any potential inheritance may be the right thing to do to help control the possibility that they'll be kicked out of Medicaid. So what are the drawbacks of Medicaid planning? And there are lots. Just because somebody qualifies financially for Medicaid and qualifies medically for Medicaid doesn't mean they get to get a bed in their preferred facility. Some facilities only take private pay patients. Others have a limited number of Medicaid beds. And sometimes those facilities are not particularly desirable. And so all of those things need to be thought about in terms of, whether Medicaid planning is the right approach for somebody to make. That there's also the potential ethical issue. If somebody's got substantial wealth but they want to look poor to try to qualify for a government welfare program, is that ethical? Does that feel right? Is that something that they ought to do? That potentially makes Medicaid available to more people and increases the cost of the program, putting stress on it, and maybe makes it harder for somebody who is poor and perhaps has a more legitimate need from being able to get benefits. All of those things are implied with regard to Medicaid planning. A question we sometimes still get asked is it illegal to help somebody with Medicaid planning? It's kind of a tricky question. There is a law in the books. It's about a 20-year-old law that said it's illegal to help somebody with Medicaid planning. However, the Clinton administration decided that that law was unconstitutional. It decided that it was never going to try to enforce prosecuting an advisor who helped a client with Medicaid planning. The law has never been enforced, and so that's some comfort to those of us who are working with clients who are thinking about Medicaid planning as we help them move forward. So what's the conclusion out of this? First conclusion is competent Medicaid planning with regard to long-term care is really hard. There are a lot of moving parts to it. We have to know our clients really, really well to give them reasonable advice, and we should never have them implement a strategy without the input of an elder care attorney. So put an elder care attorney on the team. If you're going to help your clients with Medicaid planning, you got to know as much as you can about the Medicaid rules. This is just a start today. If you want to learn more, do your research, call us up. We're happy to talk to you about it and help increase your knowledge as you work with clients and try to serve them. And then the last thing is clients should think about standalone long-term care insurance, even though it's expensive. They should think about alternative products that are available in the market. I mentioned acceleration features earlier, products with long-term care riders. All of those things ought to be thought about as alternatives to clients who are thinking about Medicaid planning. We're glad to talk to you about your questions at Advanced Underwriting Consultants. Thank you for being a part of today's webinar. We'll look forward to seeing you next month. And at this point, let me turn the program back over to Jennifer. Jennifer?
Thanks, Lennis. And thanks for joining us today. And join us next month on May 1st for another crazy beneficiary designation case. As a reminder, if you would like to receive supporting materials, feel welcome to email me at asktheexpert@advancedunderwriting.com. Again, that's asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact me at 615-224-1291. Again, that's 615-224-1291. Thanks again, and best wishes for continued success.